Welcome to the presentation on knowing your worth, salary insights, and contract pitfalls. My name is Kyle Claussen. I'm a healthcare attorney and the CEO of Resolve. We are happy to be here with you and hoping to answer as many questions as we can for you tonight on navigating physician contracts. We know that can be overwhelming. It's one of the reasons the AMA has teamed up with Resolve to provide this education to you and to provide you with some nice benefits, which we'll get to later in the presentation. So with that being said, we're going to get started, but I do encourage you to use the chat feature and the Q&A feature. We'd like to answer as many questions as we can get to during this hour once the first half of the presentation is over. So we're going to get going and talk about what is worth roughly $3.5 million to each of you individually, okay? And spoiler alert, this has to do with your compensation over your career. And so when we talk about physician contracts and knowing your worth, one of the most important things for us, because we review thousands of contracts every year and work with physicians every day, is that where you go to work, not only geographically, but also the type of employer that you're going to be with, is going to dictate what types of terms you have in your contract. And so when you look at this matrix, certainly we know that most physicians now are going into an employed setting. Private practice is not dead necessarily, but it is a minority position. 80% are now employed, meaning you're going to work for a hospital, health system, a group that's owned by private equity, an academic center, and that none of those are, I'm not here to tell you that any of those are better or worse for you individually. There's certainly positives to each. The one thing that you should expect in an employed setting is that your guarantees are likely going to be higher. And what I mean by that is not only base salaries, but also benefit packages that tend to be higher than what you're going to see in private practice. And in exchange for that, what you're giving up is some control, lack of ancillary revenues potentially, and lack of ownership long term. And so your goal, as you're looking at your contract or your situation individually, is that you want to certainly push your contractual situation as far to the top and the right on this graph as you can get it. You certainly don't want to be bottom left, where you've got low guarantees and no control and no access to ancillary revenue. Okay, and so when we think about how to evaluate a contract, when we think about what's important to physicians, the first thing that we've got to cover is contract risk, okay? So the language of the document that's going to give you potentially the most problems. We think that falls into two major categories. The first category on the left is anything and all language that's going to touch on your duties and responsibilities. There's been multiple reports on physician burnout and physician satisfaction. Almost universally, it comes back to the first three things on the left here. It's where you're working, when you're working, and how much call you're taking. And if you're taking call at a rate that's too high, or if you're being asked to work at a location that is possibly different than where you have historically or where you were promised to work as part of the recruitment process, those things cause bad outcomes, right, for your long-term employment. And certainly days of the week falls into that same bucket. So we think by solving for the language around where you're working, when you're working, and how much call you're taking is really going to be your benefit. Some suggestions that I would have for you in those areas is that your default language from an employer is going to start out saying that you're essentially going to work when and where they tell you to with their reasonable discretion. We think language that would benefit you to some extent would be that it should all be on mutual agreement, right? Or it's at least detailed to match what you've been told through that recruitment process. Same thing with call coverage. If you were told that you're going to take call at a ratio of 1 in 5 or 1 in 6, for example, and then all of a sudden you're taking call 1 in 4, we know that that leads to burnout. We know that that's not a good long-term solution. And so we'd like language to protect you, capping that call, making sure calls shared equally, making sure that the institution has to go out and get some locum coverage if there is a shortage, for a period of time. Certainly don't want that pushed all, down the line to the folks that are still there, okay? So pay very, very close attention to how your duties and responsibilities are defined in the document. The second category that falls into duties and responsibilities is anything that touches on outside activities, okay? We know that most physicians now have some interest in a side gig, whether that's being an expert witness, doing case reviews, working in social media, any type of side gig you can think of, consulting with industry. Okay, the default language is going to start saying that you're not allowed to do those activities unless you get consent, and usually written consent, from the employer. Okay, same thing would apply to intellectual property. If you're creating anything using their time, their resources, it would make sense that they would have some ownership claim on that because it's considered works for hire. That being said, the language is usually too broad. It usually covers even things that you would do on nights, weekends, right outside of the frame of employment. And so if those items are going to be important to you long term, or you think there's a possibility that they might be important even if they're not today, you want to make sure that language is tight and that you've got some protections built in for yourself. Okay. The last two things that fall into this category is anything that talks about your FTE allocation. Specifically, if you're in a teaching institution, having time carved out for research, administrative time, teaching, usually we see that done by an FTE allocation. So maybe it's a 0.1 for administrative time, which would be equal to 4 hours per week. Sometimes it's 0.2 of dedicated time in the OR, for example, if you're a surgeon. And so whatever your situation is, covering those time allocations is really important. And then finally, if you have any concerns or issues around supervising APPs, we would expect that language to be covered in the contract, meaning either capping that at a certain ratio where you don't have to supervise a certain number, and also certainly making sure that you're being paid, right, for that supervision. You're taking on some additional risk. You should be compensated for that time, okay? So your goal number one when you're spotting risk in a contract and potential pitfalls for you is anything that talks about your duties and responsibilities, make sure that language matches what you were verbally promised and what you're looking for in a position, okay? Step number two on risk is that we need to think about potentially leaving or having the contract end. That's not a fun conversation to think about while you're coming out of training, while you're looking at your first job, but we do know that most physicians will leave their first job within the first 2 years. It's about 50%. We know that there's a lot of M&A in healthcare, a lot of health systems combining, private equity buying out private practices. And so you're likely going to have at least 2 or 3 contracts throughout your career, even if you don't change locations. All right. And so understanding how the contract can end, for me, falls into 3 main categories. So it can only terminate 3 ways. It can terminate what's called for cause, which means you did something wrong. Really unlikely, but certainly does happen. These are fairly common sense items that you can think about, like you lose your license or you're unable to be insured because you had too many malpractice issues. The only issue that we generally see in that category are terms that are very, very broad and that reference duties, responsibilities, and other policies that you may violate. If you're in violation of anything that you can control, you should have some time and some notice to cure those things. All right. Now, the most common type of termination is actually the opposite. You didn't do anything wrong. The employer didn't do anything wrong. It's just time to move on to something new. That's called without cause termination. We would expect between 2 and 4 months of notice in that setting, so 60 to 120 days. You need to know how to deliver that notice and making sure we're careful on that fits your lifestyle. The reason that this is so important is because there are certain employers in the market that will lock you in for 2 to 3 years at a time. So there is no ability to terminate without cause during that 2 or 3 year time frame. If that's problematic for you, and it is for a lot of physicians because they may have a spouse that's finishing training, or they may know that they have family members that they need to relocate for, making sure you're protected in that area is something to pay attention to. And once we know how that contract can end, we've got to think about what are the financial ramifications for me individually, okay? And the first thing that comes to mind is what happens to my malpractice insurance? So if a patient sues me once I'm gone and once I've left this employer, what happens and do I have coverage? Okay, that type of coverage is called tail coverage. If you are on a claims made policy with your employer, you're going to need tail. Claims made policy only covers lawsuits that come in while you're working there. And so you need to understand that cost because in some specialties, OBGYN, for example, the tail coverage can often cost 6 figures. So we're talking $100,000 payments to pick up that policy. For a lot of specialties, it's less, maybe 20 to 30,000, but still something that has a high value, certainly as important as a signing bonus for a lot of our clients, and you need to be careful on that. If you have the other type of policy, an occurrence-based policy, there is no need for tail. It's almost pre-baked into the premium that's being paid every month. And so there is no obligation on either the employer or on you individually to pick that up. So understanding tail coverage would be financial issue number 1. The second financial issue would be any type of recruitment incentive that you took, meaning a signing bonus, retention bonuses, relocation bonuses, all of those have repayment obligations tied to them, usually for years of service. And so when we think about how long that time frame should be, it's going to increase with the dollar amount. So if you have a $20,000 signing bonus, for example, usually that's for given over 1 year or 12 months of service. If it's higher into the $100,000, $200,000 values, which can happen, we have a lot of contracts that do have those values. You'd expect 4 to 5 years in those settings. So think about $20,000 to $30,000 per year being forgiven, depending on the amounts that you took. Okay. The last area would be your production bonus. So many of you are going to be on a base salary with production model. And you need to understand if you're in those bonus categories and if you're producing at a high level, what happens to that bonus payment when I leave? Because some of them are tied to the dates of employment. And so if the payment is supposed to be paid at the end of the year, right? Let's say December 31st, and you leave on December 20th, you need to understand whether you're forfeiting the entire year's bonus because of that. And that may dictate when you give notice or when you want to leave if it is a voluntary termination. Okay. And we're going to talk about compensation specifically in a few slides, so we'll come back to that. But the last one, which is not a financial, I guess, risk directly, is non-competes. Okay, and I think a lot of you have probably followed, hopefully, the rulings of the non-competes over the last year and a half. The FTC came out and tried to ban them across the country for all different occupations, physicians included. That has since been appealed and stayed. And so at this point in time, every state still has control over whether non-competes are allowed. Okay. And so what a non-compete does is it says when this contract terminates, you're not allowed to practice within a certain area for a certain amount of time. And you can think about this as for example purposes, as 2 years post-termination and 10 miles from the practice location. Okay. So you've got this circle drawn that you can no longer practice in. That's really bad for you individually, especially from a renegotiation standpoint. The FTC thinks that in a lot of markets, because of non-competes, physician compensation is being suppressed by 37%, which is a really big number. It's about $111,000 per year, and it'll cost you $9.3 million over your career in lost earnings. So if the location is important to you, and it is for almost every client that we talk to, they're either moving home or they've got a spouse with a job right in the area, or there's, kids are in school, the non-compete is going to limit your ability to renegotiate. So your goal with a non-compete is to really shrink that radius as much as you can, because geography, again, is the most important thing. So if it's 10 miles, right, 5 miles is better for you. You also should hope to have some exclusions to that non-compete for things like no-fault terminations or the employer being in breach of contract, things that aren't your fault that you can't control. And you also may want to consider limiting it based on scope. So when we talk about scope, this would be, for example, an internal medicine physician that can work in an outpatient setting, but also as a hospitalist. Okay, if you're working as a hospitalist, you would expect to then not be prevented from going to an outpatient clinic because you weren't, performing those services for that employer. So your goal with a non-compete, if you can't get rid of it entirely, and if it is allowed in your state, is to limit these terms as much as you can. Okay. So those are the major components of contract risk and the things that I think you should, at minimum, be checking off. So let's move into compensation and talk about how you're going to get paid and what that looks like from the contracts that we've seen. Okay, this is a example of the occurrence rates of these different types of compensation that you're going to look at in a contract. And so on the far right, you're going to see a base salary and production bonus with a 95% number. Vacation and CME, the same thing. Those are 4 items that you should expect to see in nearly every contract. Okay, very high occurrence rate. You're likely going to see a signing bonus. You're likely going to see relocation allowances as well. Those numbers really can vary based on location. Again, we talked earlier, they can be as high as $200,000, maybe more in certain settings. They can be as low as 0, right? There's certain practices that don't provide them at all. But something to think about, something to ask for, especially if you're coming out of a residency or fellowship. Now, things that are less likely to show up, but still can. One is a student loan forgiveness. Very high need. A lot of residents and fellows have student loans. We only see that showing up at about 10%. Retention bonuses would be kind of the equivalent to a signing bonus, just paid at the end of each year. Those are only at about 15%, and then stipends as well while you're finishing training. So payments coming to you during your last year and a half at about 10%. Now the two in blue, the quality components and the APP supervision. The APP supervision is completely dependent on whether your practice has that, I guess, capability or that type of practice where you're having NPs and PAs with you. If that's the case, you certainly should be paid. We usually see that in a flat dollar amount per APP that you're supervising per year. You also may see quality components, right? Not tied to APP supervision, but just quality components in general. There's been a lot of talk about shifting more compensation to that bucket. We have not seen that at a very high rate yet. Oftentimes, the quality metrics are very subjective, and physicians are trying to limit that to, hopefully less than 5 or 10% of your total compensation, right? Because it's things that aren't necessarily always in your control, right? So that's the makeup and the types of compensation that you should be thinking about. But let's talk about the core of your comp, okay? So the core of your compensation is still going to be structured mostly on a base salary, mostly with some type of production metric that you're asked to hit, and then a certain bonus payment after that. And so I want to walk you through the three main types of models that we see. You likely will either be compensated on the work RVUs that you produce or the collections that come in, and potentially gross charges or billings. Okay, that one's less likely to occur. So we're going to focus on the first two columns here. And the example that I want to hopefully drive home to you is that it's not just base salary that's important. Your production threshold and conversion factor, or that multiplier, is going to drive a lot of long-term compensation. So let's walk through the first column on the left. If you get a contract that has a base salary of $200,000 and your production threshold is 3,000 work RVUs per year, and then you bonus at the rate of $40 per work RVU. Okay, that's the example contract we're looking at. You go to look at the data to see if you're being paid fairly, and the data says the median is also 200,000. So we're okay on that first line, right? We're right where we should be. We go to look at the median work RVU production for my specialty, and it's only 2,500 per year. Okay, so that should be causing you to question, one, how that number was arrived at in your contract, and then two, you should be starting to quantify, right, what that does to you financially. And so if we know every work RVU is worth $40, and we know you're being asked to produce 500 more than your colleagues and your peers, 40 times 500, right, is $20,000 of value and $20,000 of compensation that your peers would have earned, right, if those medians are correct, that you're not. And so we've got a 10% gap here, right, in market versus what you're being offered. And so the ways to solve for that are either to increase the base by that number to 220,000, or to reduce your threshold from 3,000 to 2,500, or if it's a very high volume practice and they can show and prove to you that you're going to go well past the threshold, would be to increase that multiplier, right? So even if you're at a deficit early, in the year, by the end of the year, you're back in a positive where you should be. Okay, so the goal would be to earn at the correct percentile or the correct amount, regardless of your production. Okay, same type of concept would apply to a collection model. We'll go through that real quickly here. But if your base again is 200, the market's actually 190, so you're being paid above median, or at least being guaranteed above median by 10,000. That's good. But when you look at your production numbers, if median's 500,000 of collections and your contract says 600,000, and every dollar is worth 30% or 30 cents on the dollar to you personally, you've got a $30,000 deficit in your production side, even though you're positive 10 on the base. So you're still short $20,000 when you combine those, as opposed to what the market would say for your specialty for that location. Okay, and so we want to make sure that, again, regardless of where we're producing, we're earning as close to fair market value as possible. Okay, so all of this should beg the question for you is, where do I find that information? How do I know what's fair? How do I know what median looks like? In my mind, there's three good categories of data that you can look at. The first category is the surveys that your employers are using. So you may see in your contract references to surveys like MGMA or AMGA, Sullivan and Cotter, AAMC, and there's a few others that we'll see referenced. MGMA is generally the most widely used by the employers that we deal with. This information comes out once a year, usually in May or June. It's used for fair market value compliance, right? So if you hear that there's a potential Stark issue or an anti-kickback issue, or an IRS, fair market value issue, they're usually referencing back to these surveys. And so it's really to your benefit to be able to understand that, to be able to compare those things when the employers bring that information out. The second type of information is what we call market intelligence, right? It's the Our Data feature on resolve.com. It's going to show you a live stream of contracts that we're seeing, because a lot of times the market shifts faster than once a year. All of the data is verified from physicians. It's de-identified, right, and anonymous. And it also has other value points to it, not just base salaries and work RVU numbers, but it's going to show you what normal non-competes look like and who's paying for tail and who's not, right? So you can have a better holistic picture of the full contract. So that's important data to have access to. And then finally, I think that the most important data point for you is actually having other job offers. Okay, so if you're coming out of training or if you're moving mid-career, understanding who's hiring in the area at the time that you're looking and having those offers, one, it's verified data, but two, it gives you leverage, right, for any type of negotiation that you may want to have. It's also, again, live and sourced from you, so you can trust it, right? So my recommendation when you're looking at data would be to get your hands on all three of these things. The MGMA data, the data on our site with Resolve, and also hopefully a couple of job offers that you've got in hand. And with all three of those, you should be able to have a pretty good idea of what's fair for your specialty and for that area. Now, I wish it was as simple as saying, let's plug this information in and I just get an absolute number back. When you talk about medians and when you talk about any data set, right, there's a lot of different ways to pull medians, because you can filter these data sets about 252 different ways. And so the numbers on the screen here are showing you medians for a certain specialty, and there's quite a difference, right? There's a huge lifestyle difference between 312 and 657. It's a lot of student loan debt that you can pay off in 1 year. And so if anyone tells you that this is the median, it's a fairly loaded question, right? You need to ask how they got there, what geographic area they were looking at, what type of demographic filters they were using, because we want to maximize or at least understand what the range is, as you're going into negotiations, and being able to do that in good faith, right? So you have to understand those ranges. The other things that I would tell you is that data shifts on an annual basis. So it's very, very important to look at this at least once a year, right? To make sure you understand whether or not your compensation is keeping pace with your colleagues. This is an example from 23 to 24. You can see things like total encounters going down in 2024, but total compensation at the bottom staying relatively flat, which means that the dollar per work RVU is going up, right? Or the payments to physicians are going up, even when volume, fell slightly. And now this is not for every specialty, but this is just an example of one. So you have to know what's going on every year in your specialty and make sure that you're informed, okay? Now, the last step in this, you hopefully are going to understand risk, right? You're going to know what the language should look like. You're going to have access to data and have access to information to empower yourself. You have to then decide whether or not you're going to negotiate and how you're going to go about that and what to expect in that process, all right? And the first thing that you're going to hear from every employer, it doesn't matter how big they are or how small they are, is that they have a standard contract and they want to keep that contract the same, right? This is the same offer that they make to everybody. From where we sit, if you have leverage, if you've done your homework and you're asking for reasonable adjustments, it's really hard to recruit and really hard to retain physicians. 85% of the contracts that we see do have adjustments to them, whether that's numbers or language. And these are just a couple examples on the slide here for you to take a look at. Sometimes you have to take the position of almost walking away. So the example on the left came back with a no to compensation, right? Unfortunately, we can't match the base and the RVU adjustment. The physician decides to politely decline, right, and go somewhere else. And the very next email that came in was, we've received this, we've sent it over, they might be able to reevaluate the offer. Is there anything that is a must-have for you? And so that's an important, thing to understand, is that this is a business, right, for them and for you, and you've got to make the best decisions for you as possible, okay? The last thing I'll tell you, and I see there's questions starting to come in, so please use those because we're going to get to that in a minute, is that everyone has a fair market value consultant. And when I say everyone, I mean all of the employers, right? They have legitimate concerns on Stark and anti-kickback and IRS rules that they have to comply with. And so they may get essentially an appraisal, right, on your services of what it's going to look like. And this is an example of sometimes how that comes back. The employer confirming, right, with their fair market value consultant that the data from AMGA and Sullivan and Cotter was used to inform that. They're not going to provide the physician with that analysis, but hopefully you're assured that there's a large desire to have that physician work there. I think that's true, but I think you also need to be able to validate, it's kind of trust but verify, right, what's happening, which is why we think it's so important for you to have access to this individually. Okay. So what Resolve is and why the AMA has teamed up with us is it's a platform for you to utilize to evaluate your offers. So you can upload your contracts into this, get access to the data that you need, be able to see, kind of that live feed of contracts that are coming in, and to connect with experts if you need help, right? If you need an attorney to help downstream, you can certainly use that as well. And the reason the AMA thinks that's so important, and that we do too, is because if you're short by 10% in your compensation over your career, that 3.5 million we talked about is lost earnings. So you have to pay attention to this. You have to be empowered and understand your worth and know your values, so you can have these educated conversations when you're talking with your future employer. And so the AMA is providing you with a really nice discount. If you want to use the platform, it's usually $200 a year to get access to that. You can use this QR code to get that for $99 for about a day and a half. That code expires 10/17 at 6 p.m. There's also, if you want more full services, the AMA has got you 20% of a discount as well. We can maybe drop that link in the chat, Melissa, on the AMA's website. You can log in and use that member benefit as well. So with that, I'm going to take your questions for about the next 30 minutes if we can. And also, if there's personal questions that you don't feel comfortable asking in a group setting like this, the email on the screen, Kyle at Resolve, you can certainly email those over as well, and I'll do my best to answer those in the next day or two. So with that, I'm going to get to our first question, which is on student loan repayment. If we don't need the loan repayment programs that an employer might offer, can we negotiate for additional bonuses or increase anything else in the contract, like salary? My recommendation is yes. So if there is a dollar amount that's coming directly from the employer, whether that's a signing bonus or student loan repayment or anything else, that's a budgetary item that they can reallocate. Now, if they're using a state program, right, if there's, certain states have programs for student loan forgiveness for physicians, that may not be something that they're able to move around and control. So I think it really depends on your situation. But I would certainly start out with the ask, because if there's a large value that you don't need, you want that reallocated elsewhere. Potentially a retention bonus would make sense, because that's a similar payment process as what a student loan payment would be. So good question. Any other questions that I can answer live? Okay, if you're in a two-physician family, marriage, is it common to forego one of your health insurance plans in exchange for a higher base? The benefits are tricky, because there are certain benefits that they can be flexible with, like relocation allowances and CME funds. Other things like health insurance or disability insurance, life insurance, right? These group plans, they can't only offer those to certain people, right? So they can't discriminate. And so you could certainly not take the health insurance, and that would be a benefit to the employer, right? They wouldn't have to pay for that premium, but it's also not something that they can mandate that you not take. And so usually we don't see any adjustment for that, because what their concern would be is that you would come back in, after they've given you the compensation increase, and then you would take the health insurance, and legally they can't prevent you from doing that. So I think you'd be better off pushing somewhere else than trying to get them to recompensate you on the health insurance. If I don't need relocation money, can I ask them to add to the signing bonus? Absolutely. The most common number that we see for relocation is about 10,000, maybe 15. I think the highest we've ever seen is about 30,000. And so I think if that value is not needed by you, or you can just get by with less, certainly I would reallocate those buckets and shift those amounts around to something that you can utilize. Okay. Can I please walk through the RVU production examples again? Yes, we can go back to that slide. Bear with me here for 1 second. Okay, I think it's this slide that you're asking on. So I'll give you the quick example again. If you're looking at a work RVU model, your goal is to analyze, if I produce at median, what do I earn at median? Okay, and if I produce at the 60th percentile or 70th percentile, what do I earn at that level? And so in my example, I've got a base salary of 200,000 with a contract threshold of 3,000 work RVUs and a contract multiplier of $40, which means those are the contract terms that I've been offered. And so if I go to look at the data that's out there, right, on our site, and you say, okay, well, the median is 200,000, right? We think that that's good, right? You're at median. But if median production is only 2,500 work RVUs, it means to me that your contract is asking you to produce an extra 500 work RVUs with no compensation. Because when you produce at 3,000, you earn 200. When your colleagues produce at 2,500, they also earn 200, right? And if every work RVU is worth $40, that deficit, that $500 or that 500 work RVU deficit, when you multiply that by 40, that's $20,000 that you're short. And so it's not always to your benefit to take a really high base salary if your production metrics are out of line. Sometimes we've actually seen total compensation for clients be much higher at the end of the year if their base is a little bit lower, but that also in turn means that their threshold is lower and that their multiplier is at the right level. So I think you just have to, take a look at the market data that's out there, analyze it to your situation and say, okay, where do I fall on this based on this hypothetical production that's out there? I hope that helps. If not, put another question and we'll try to answer it. Okay, do I recommend using a recruiter? How do we know if a headhunter is contacting us for a job that's looking to take a big cut? Well, recruiters there's a couple different types of recruiters. First of all, there's in-house recruiters. So I'll use Mayo Clinic, for example. Mayo Clinic has an in-house person that works for them. They are not paid on commission, right? You can think about them as almost like HR, right? They're hiring and helping bring people into the system. There's also third-party recruiters, and that's who I think you're referencing that would take a cut or a placement fee. There's lots of those out there. I think there's 2,000 plus recruiting firms in the country. And so what happens is that if they are introducing your resume to that employer and that employer ends up hiring you, they get a fairly large, payment, right? It's usually $30,000 to $100,000 depending on specialty. And so if that's the case, and you can get by without using a recruiter, it would make sense, right? That the employer saved, maybe $100,000 in recruiting you that they could reallocate to a signing bonus or something else. So I do think it's important to understand that of how you got introduced to the job. And if you can do as much of this homework on your own as possible, I do think it puts you in a better position for maximizing your compensation, at least in that first contract. I don't think it's going to affect downstream, base or production numbers, but I do think it will help with getting more signing bonus or relocation. Okay, what kind of attorney should we get to look over a contract? Well, this is very biased because this is what we do, but you should have a healthcare attorney. Okay, so you need somebody that does this all day, every day. Please don't use a cousin that does divorce law to take a look at it, or a tax attorney that happens to be your uncle, those types of things. I mean, you want somebody that specializes, attorneys specialize just like you guys do. Make sure you have somebody that understands not only the legal pieces, but also the financial pieces and what things are worth. You don't want to miss on things like tail, right, or other pieces that are going to cost you potentially $100,000 down the road. What about negotiating contracts or compensation based off of skills, such as being fluent in multiple languages? Certainly possible. So if a practice is located in an area that has, a very heavy patient population in a certain language, it may be really beneficial to bring you in because they can capture that market. That being said, none of your collections, right, which is what all of this is going to be based on at the end of the day, distinguish between whether or not the patient was Spanish speaking or English speaking. It doesn't distinguish between how long you've been in practice, right? You don't get reimbursed more for a cataract because you've been practicing 10 years as somebody who's been practicing one, right? The reimbursements are the same. So I do think there's value. I think absolutely you should be promoting yourself with all of your skills and the things that you bring because you may capture more patients, but it's not going to change the downstream financials of the business. And so I think you need to be aware of that as well. Where to see contract trends? Okay, so if you're using the QR code, right, that's on the screen, you're going to have access to a live stream of contracts that are coming in your specialty. You're also going to be able to see access to, the survey data that we talked about. And if you're working with a higher level, like with an attorney on our team, they're able to filter through and look at trend data, more detailed filters. So I think at a baseline, you're going to want to make sure you know what the market is doing, right, at the kind of the platform level. But if you're really interested in 3 or 4 or 5 year trends, I would suggest using that 20% off link that Melissa put in here to take a look at that, because that's where you can get into the custom reporting, which might be what you're looking for. Is vacation time usually negotiable? I would say that about 50% of the time it is. So it depends on the practice type and your specialty, and honestly how much is being offered as a baseline. But certainly you can negotiate vacation. That's not a benefit that has to be legally offered the same to everyone. There are certain specialties and certain roles, right? Like when hospitalist contracts come through, there's not a lot of vacation there. Sometimes there's a week. In other specialties, I think of radiology as one where there may be 8 to 10 weeks, right, at times, or even more. And so I think it's certainly something that there's flexibility on. It may change your compensation, level, right, or guaranteed compensation. But I think it's certainly something you should push for if it's important to you. Does the contract include only base salary and quality metrics without additional work reviews? Is it worth in current market scenario? I'm not sure I fully understand that, but I think there are contracts that don't have any production, if that's the question. And I don't know that those are necessarily bad, right? If it's just base and quality, I think you'd want to take a look after your first year as far as what you're producing. So I think, if you're close to median from a production standpoint and your base is at roughly median, then I think it's fine. If you're producing at the 90th percentile and you only have a base that's at median, you're leaving a lot of compensation on the table. And so I think that's going to be one that you're going to have to either build in on the front end to ask for that production, or you're going to have to go retroactively and look back after you've been there a year to make that renegotiation. Okay. If an employer has malpractice but no tail coverage, should I run? No, not necessarily. I think there's a lot of practices that have a claims made policy, right? Which means they don't offer tail. I think it's a financial decision for you on how much tail is going to cost. All right. It'd be no different than if a practice didn't offer a signing bonus. I wouldn't tell you to run away from that. But I do think you have to, as you're comparing your offers, understand that the one without tail is coming with a payment later on that you have to make, or that your next employer has to make, right? It may not be cash out of your pocket, but still, then it's maybe a lost signing bonus with a future employer because they have to pay for tail from your previous. So I wouldn't say run, but I would say negotiate that point. Do I think it's possible to do all of this with this information from Resolve without an attorney? I think that depends on you individually. There are certainly a lot of physicians that are very equipped to understand the risk, right, to utilize the tools on our site, to have access to the data and the information, and then they feel more comfortable having those conversations on their own. There are certainly a lot that benefit from having a third party help with that process and having somebody like myself to bounce, right, these questions off of and ideas off of. So I think it's possible. I think that's a very personal question, though. How long is the instant review valid for if purchased? What's the difference between instant? Okay, so the instant review is essentially the platform, right? You're getting access to that for 12 months. So you're going to have access to that data from now until October 14th, right, of 2026. The difference between that and the 20% offer is the 20% is for everything that's upstream from that, I guess, is if you need an attorney to help, that's when you're going to get that additional discount of 20% on those services as well. Any special considerations we should keep in mind when looking at a locum contract? Yes. The biggest one is that if you have any interest long-term in being in the location where the locum contract is at, you have to be careful that there's not a non-solicitation or a non-interference clause, which essentially says if you're going to walk in and take this contract from us, right, because we're the locum company, and if you want to contract directly, there's usually a fairly hefty buyout that you have to pay to do that. So that's number one, if you have that interest. If you don't, the biggest question would be is my malpractice insurance and tail coverage there? can I get out of the contract quickly? And also, is my schedule something that I have control over? If you can solve for those three things, there shouldn't be any type of non-compete, right, or preventing you from working anywhere else. It's usually that they're just protecting the contract that they have with that facility. With the percentage of physicians who leave their first job within 2 to 3 years being substantial, do you agree with the commonly said teaching of not being dead set on your first job, of being in your dream location? Not necessarily. So I think the reason physicians leave their first job within the first couple of years is that they go in unknowing to their contract setting. They go in trusting that the situation will never change, that the recruiter that was there is going to be there for 20 years, right? And all the promises that were verbally made are going to be kept. The reality is that hospital administrators move around, and any executive moves around just as much as physicians do. And so the person that you're dealing with may have been absolutely right, honest in saying, yes, you don't have to work Fridays, for example. But when the new CEO comes in, they may want to maximize revenue. And they may say, well, your contract says you're supposed to work, right, because as we dictate, and now you're going to work Fridays. And it's those types of things that happen that could be solved contractually to help you, right, not have to leave that dream location. I do think, though, if it's your dream location, you be very, very careful in the non-compete, because if there's one in there and it doesn't work out for whatever reason, now you have to move. So I think that's regardless of when you would end up landing in the dream location, is that you've got to be prepared to have another option if it doesn't work out. If you theoretically saved a practice a lot of money in recruitment costs by coming to them first, rural, for example, is it fair to use that as a point of leverage when negotiating a sign-on? Yes, if they didn't have to use a recruiter, I think it's fair to ask for that. Also, rural settings tend to have the highest sign-on bonuses anyway. Again, that's some of the data that you'll see if you start to filter through it. You'll see fairly large signing bonuses in certain specialties. So I think you can absolutely negotiate that. Would I say occurrence-based malpractice insurance is usually better or more advantageous than claims-made insurance? The answer would be yes. If that's occurrence versus claims, just generally, occurrence is better. Now, claims plus tail is the same as occurrence. So if your contract says there's a claims-made policy and we provide you with tail coverage later on, then there's no difference between that and an occurrence-based policy for you individually because they're taking on that cost. Are the terms in an offer letter subject to negotiation? Is it even an official contract? Should I accept the initial offer and plan to negotiate later? For the second half of that, absolutely not. If you want to negotiate, you should do it the very first time a term is presented to you in writing. I don't expect you to negotiate in an interview, but I do think if you get a letter of intent, even if it's not legally binding, most of them aren't, but some of them are, is that it's really, really difficult to go back if you've signed off on a base salary of 200,000, for example, or 300,000, and then you come back and go, well, whoa, I looked at the data, it actually should be 350. It's unlikely that they're going to move from that, or if they do move, it's going to start off the relationship on the wrong foot. So I think you always negotiate right away on the terms presented, and then you negotiate other terms later when they're presented in the full contract. How much of bonuses are fully taxed? Any benefit for physicians for those paying loans? Can the amount be paid to loans be pre-tax? Well, this is a big disclaimer. I can't give you tax advice, but I can tell you that bonuses are taxed as ordinary income. They may have withholdings that are slightly higher, but at the end of the day, when you go to file your tax return, it's not any different than wages. Same thing on your student loan, right? If they're making payments to you, there's certain laws that maybe the first 5,000 are going to be tax-free, but after that, it's all going to be taxable income. And so there's really not a good way to get around that. Now, you may work with a CPA or to your tax advisor to maximize other deductions to help reduce that, but you're going to have to claim that as income. What kind of trends are we seeing in contracts for new H-1B visa applications, given the potential fee of 100,000? Not a lot yet. Now, that being said, those fees and fees on employers are certainly going to affect the ability to hire and the ability to offer other large benefits, right? Like signing bonuses or relocation allowances. There's already, usually $15,000 to $25,000 of fees for any J1 or H1B that's happening, with those immigration costs. So it's not an unknown or anything that's unusual. It's just that the amount, right, has this potential to increase. So not yet, but I would assume that that's coming. If they are verbally promising the number of calls but not putting it in the contract, is it considered too much to put the details in? No, it's not too much. And that's actually one of again, the most common areas where people have burnout and where we have mid-career physicians coming back in for renegotiation saying this is the number one deal breaker for us is that we have to have our call defined. Um, it's not that you wouldn't occasionally take more call, right? Or if someone's on vacation, you wouldn't cover them. But it's if you're in the situation where there's six of you and two people leave, right? And now your call is 1 in 4 versus 1 in 6. That's very different from a lifestyle standpoint. The facility should be able to go out and get locum coverage while they work on hiring and filling those slots. It shouldn't just fall to you to pick up that call. And if you are picking up the call voluntarily, you ought to be paid for it, right? You can't have additional responsibilities without compensation. Is there a map or a place to see underserved areas where maybe there's more bonus? Well, you can certainly sort the contract data on our site by state, and that will help you, right? Start to see who's offering what and where. You could also, I mean, just search, population. Usually it's based on population. The more rural areas are going to generally pay more. Sometimes inner city, right? It's really the hard to recruit areas if you think about it that way, are what you should be paying attention to. Is there a compensation model that's most advantageous per specialty? For example, highly procedural surgical versus less psychiatry. I don't know that's most advantageous. I think it's probably practice type, right? Dependent and on what types of volumes are there and what type of payer mix they have. Certainly if they're in a really good payer mix, a collection model might be better because the dollars coming in are higher for the same work being done. And then alternatively, a work RVU model might be better if you're not wanting to worry about who the payers are, or if you have a lot of Medicare, Medicaid patients coming in. Because when you enter those CPT codes, right, it has an equivalent corresponding work RVU value. And so if you're being paid on that, you don't care about collections. So I think it depends on the practice setting and who the payers are. So never negotiate in person. No, I don't think that's true. I think that you can negotiate a lot of different ways. You can do it via phone, via email, sometimes it's via Zoom or Teams, sometimes it's in person. I just think you want to make sure you're prepared for the negotiation, that you understand what you're asking for, that all of your data is backing you up. And if you're uncomfortable with that, that's when I would say get some help. Have a third party, or an attorney go alongside you with that, because I think that'll be to your benefit in that setting. Any thoughts on negotiating on the phone versus email? Okay, maybe same person follow up. I think there's some things that are fine via email. I think a lot of it, though, you're going to get better results if you can do it with some context and with some, explanation, maybe, especially around things like call, of why it's important. Oftentimes when we're negotiating, legal doesn't always have the understanding that operations does. And so it's helpful to have, maybe the physician, and somebody from operations come alongside to say, yes, this is actually the deal. Let's document it that way. Let's make sure it's clear. So it depends on what the term is that you're asking for. Sometimes emails are fine for language tweaks. For big things, probably the phone or Zoom is better. From my understanding, those job offers with stipends while in residency are rare. Any tips on the best way to find those? I think it's the underserved. It's the jobs that have been open for a long time. Really, all of a stipend is an advanced signing bonus. And if you have to repay the signing bonus anyway, over 1 or 2 or 3 years, you're still going to have that obligation, right? If they pay it out early. So as long as the practice has the available cash flow to do that, I would say the most in-demand jobs are the ones you should be looking for. Okay, how much time is professional or reasonable to decide on a job offer? That depends. So we've seen offers that have expired within a week. We also have had offers that have been out for 9 months, right? And the practice is just fine waiting. So general rule of thumb, they're going to want an answer within 2 to 4 weeks, which means you need to be thinking about all of your interviews, hopefully roughly at the same time or as close together as you can get them. So you're comparing those offers side by side within the same month. What you don't want to do is put pressure on yourself from a timing standpoint to have to say yes or no to your first offer when you haven't even interviewed, right, at your third option. And so you want to, again, do your planning now, especially if you're in your last year of training. Practices are hiring. We have a lot of contracts already signed for 2026. And so I would suggest interview together, as much as you can so you have all those offers at the same time. Really good questions, by the way. Anybody else? Is it advisable to accept a job offer and then negotiate on the contract? Excuse me. And then negotiate on contract clauses that were not earlier discussed? I don't. If there are contract clauses that weren't discussed and you accepted a letter of intent, I think it's and they weren't mentioned. I think it's perfectly fine to go back and renegotiate those. If you signed off on a contract and then the situation is changing, I think then it's a question of are they in breach of contract or does the contract actually allow them to do that? So I think that's why you've got to be very careful with what you're signing and very careful on not signing a binding letter of intent until you know what the full contract looks like. Do I see physicians more pleased with work RVUs or collection contracts? I think it depends on specialty and payer mix and location. I think there's this idea or the concept of I don't have to worry about who the payer is, that work RVUs, can benefit. That being said, there's been some changes to the, from CMS on fee schedules and what codes have certain RVU allocations to them. And so that's been kind of a mess from 2020 until now, where collections is much more straightforward, right? But if you get a bad payer mix, right, then it may be harder to get to those bonus levels and those thresholds. So if you're going to be on a collection model, I would hope that the practice or the organization could show you historically what a new hire has generated. Obviously, collections trail, so you're going to have a big old zero right in your collection bucket for the first 2 or 3 months, and so you're going to have to decide in year one how quickly you can catch up, and really it's probably a year 2 bonus that you'd be looking at in that setting. Is it atypical not to negotiate if you're generally happy with the contract? Should you feel bad? No. I mean, there are some contracts that, we look at and the clients are pretty happy with. I mean, there's certainly always something that I think you could change, right? They're never 100% perfect, but if you're happy with it and you have no concerns and you're fully educated, so you're not, you don't know what you don't know type of thing, as long as you're okay with that, I think you can sign. I mean, there's certainly some clients that'll go through the process, be educated, understand what the risks are, and then decide this is still my best option, even with those risks, and they'll sign off on it. I think that's perfectly fine. If I know I'll be leaving in a year, should I forego the signing bonus to avoid repaying with interest? I would not. I think anytime somebody's going to give you compensation, you should take it and you should invest it and you should generate the interest yourself on that. Even if you have to pay back the principal, you'll at least be right. You'll at least be positive on the interest side. I think it depends on how quickly you're going to be leaving and if you can get that maybe forgiven by month rather than at the end of the year. I think that's the question to ask yourself and what your terms of the contract say. But I would always take a benefit that's there. I don't think it's to your benefit to not take a signing bonus. Do I advise signing a 2-year contract in advance? Signing now for a 2027 start date, maybe. What I'd be careful on is one that the location you're absolutely set on the location and the practice, but also that you'd want to make sure that the compensation is going to adjust. So a base salary of 300,000 now, median might be 320 in 2 years or 340 in 2 years, and so you may want to have some, qualifications or some, look back to say, okay, we're gonna reset this when I actually start if market has shifted. Is there any way to protect ourselves from insurance downgrading within a contract, especially with RVUs? Well, with RVUs, it shouldn't matter because you're not worried about insurance and with the payers. Other than that, the answer would be no, right? I mean, if insurance denies something or doesn't reimburse for it in your model set on collections, I think you're in a tough spot. That's just kind of part of the practice. Okay, well, I think questions have slowed down or at least stopped. I'm going to, again, give you my email. It's kyle@resolve.com. Please, if you have any interest in this topic or getting help with it, utilize the AMA benefit. It's there for you. They want you to utilize it, and we're really happy that you hopped on tonight. So have a good rest of your evening.